Hello, I'm Nancy Zenger-Beneda. I'm going to spend some time talking with you about tort law and how it relates to community colleges. Tort law is a civil wrong where a claimant can suffer loss and perhaps receive damages because of something that someone else may have done to that person. But there's actually several types of torts. They can be intentional when someone does something purposefully, or it can be unintentional when there's an action that occurs and then there's an unintended consequence. And then there can also be a tort claim when there's negligence. As I looked at groups of cases that affect community colleges, alcohol seemed to be the number one type of case related to community colleges. A lot of the cases that I looked at were related to drinking and driving. There were also assaults, some cases where students fell after they'd consumed large amounts of alcohol, and even drowning. In the particular case I looked at, McClure versus Fairfield University, a student was struck by another student that was walking from an area where students typically consumed alcohol across the street to campus housing. The allegations included that the university knew students consumed alcohol at that place, and in fact even provided safe rides on weekends for students who had been drinking and would need to return to campus. And because of that, were actually found liable in that they knew students drank and they were providing services sometimes, but were not at the time of the accident. And it was particularly interesting to me because we have a local organization here, dance club, that students attend and consume alcohol, dance. And at one point, the college was providing rides on the weekends for students to return to campus housing from that location. And our concern at the time is that local police were really targeting our students for DUI. And the organization is now closed, so we don't have to worry about that. But I realize in hindsight, we could have been liable because we were not providing those rides all the time, mostly just on busy weekends or nights that we knew were particularly popular. Another area of cases that I looked at were assaults. So the real question here is, what's the college's duty or obligation? And through the cases that I looked at, colleges are not provided to necessarily provide police protection, but they are obligated to warn students of security risks or incidents that have happened on campus. And I do know that we, through the Department of Education and the Clery Act, publicize information about incidents that have happened on campus and to warn students of any risks that there might be. In the particular case that I looked at, Peterson versus San Francisco Community College, there was a daylight rape or attempted rape on a stairwell that had a lot of shrubbery and greenery next to it, which provided a place for a perpetrator to hide. And in fact, there were other instances that had happened at that exact location. So the college was found liable because they hadn't informed students that incidents had taken place at this location, and then they also hadn't taken precautions to reduce the likelihood of something happening there by removing the shrubbery and increasing the safety of the environment. And in fact, we just went through campus and cut trees and increased lighting just to take a look at our facilities to make sure that we were providing the safest environment that we could for students that were moving between the college to campus housing. Another area of case law that I looked at were shootings. And again, we ask, what's the college's obligation or duty? In Peterson versus the San Francisco Community College, there was a registration day happening, and a student actually made a threat to another student as they were standing in line to register. That student that made the threat left the college The student that received the threat did report the threat, but he was reassured that the place was secure and that he would be safe, and so they went on with registration day. The student actually returned then with a briefcase and confronted the student that he had threatened earlier, then walked away from that student and then turned and shot the student. In this particular case, the college was held liable. They failed to acknowledge the return of the student, and he did come in with a briefcase. No one confronted him, asked him to leave. And some other things that came through or resulted from this case is that administrators and security personnel do have the right to ask students that have presented some kind of a risk, or visitors, people on their campuses, to leave the campus. And if those people would refuse to leave, that becomes a trespassing violation, and so they can be charged accordingly. The college does have emergency policies and procedures in place. We do have an emergency response plan, and actually today we just went through a live drill of a violent intruder. So we do practice handling those situations. We learned a lot. There are many things that we can do to improve, but we are taking these security concerns seriously and doing our best to prepare our faculty, staff, and students for any threats that we might see in the future. Another area of tort law we looked at is related to sports, and the torts can be related to athletic injuries, injury care, crowd management, even facilities and equipment. The specific case that I looked at, Avila versus Citrus Community College, involved a college baseball game, and one pitcher from Team A hit a batter from Team B while batting in the batting box. And then when the teams changed field positions, the pitcher from Team B hit a player that was batting actually in the head and split his helmet open. Allegations included that the pitch was thrown intentionally, that the management staff of the team had actually instructed the pitcher to do so. Also that the student that was hit did not receive proper medical care. And even that the equipment was faulty and that the helmet failed. Some interesting things that resulted through this case is that the college was not found liable for the actual injury, in that athletes accept a certain amount of risk when they step out on the field. So they could not prove that the pitcher did it intentionally or that he was instructed to do so. However, the college was held liable for not giving the student proper medical care. He actually walked to first base and then made it to second base when they brought in a pinch runner, and then went to the dugout and stayed in the dugout and did not receive medical care. So the college was held responsible for not providing that player with adequate medical care. Interesting in that we are currently in a case with a student who is alleging that he didn't receive proper medical care for an ankle sprain while playing basketball for us. Even though we have policies and procedures in place and our staff did absolutely everything that they should have done, we are still experiencing a lawsuit and relying on our liability insurance to help us get through that situation. Another and the final area of tort risks that I'll talk about this evening is the classroom risk. And especially at the college level, where we're doing lab experiments, we're working in the chemistry lab, physics lab, we have an ag unit where we're doing hands-on work with livestock, there is a particular amount of risk. In looking at this section of tort law, some of the things that I learned is that the college is responsible for warning students of the hazards of the activity that they'll be participating in. The college is also responsible for providing the necessary safety equipment and having appropriate facilities and equipment for the students to work with, and for providing close supervision while students are participating in those activities. The particular case I looked at was Brigham Young University versus Lily White. This was a chemistry lab explosion, and the student alleged that she was not aware of the dangers, and she was inexperienced and was put in a situation that she was not prepared to handle. And in fact, the college was not held liable because the instructor did have a lab manual that he'd gone over with students and could prove that he had done so, that contained all of the information that a student would need to know in preparing for the work that they were going to do in the lab. There was also a lab packet that gave very clear instructions on how to do the assignment and how to work through the experiment. And then while all that was happening, the instructor was close by providing supervision, and in fact, it was proven that he had adequate experience and knowledge to be providing the supervision for that situation. So in that case, the college was not held liable. In summary, what I have learned is that colleges really can be held liable for harm to students, faculty, staff, or even visitors through tort claims. And the administration must be knowledgeable of their responsibilities, that activities that happen on and around their campuses and their facilities. Thank you for spending some time with me. I hope that you learned a little bit about tort law as it relates to community colleges, and specifically appreciate the need for having liability insurance and legal counsel that could help an institution or an individual through any tort claim or situation that he or they might find themselves in.